Welcome to How to Identify and Manage the Legal Risks You're Going to Encounter During the COVID-19 Crisis. We have Dan Fredrickson from KO Law Firm presenting today.
Thanks, everyone, for joining. One of the things that KO does with clients is we often serve as their outsourced legal team, right? They're outside general counsel or an extension of an in-house team, but in that capacity, we have really been on the front lines with clients about questions and concerns that they're facing in light of COVID-19 and the related government orders that have followed. And so what we've done here is compiled some of the most common issues that our clients have been facing that we've been talking about over the last month, and hopefully aim to give you some guidance that will help you as you're working through the issues with your particular businesses. So just jumping in, that's me. Mike already talked about me. And of course, this wouldn't be a presentation from a lawyer unless I threw in a proper disclaimer. Of course, the information we're talking about is general in nature. We're not giving specific legal advice. If anything piques your interest or you have any questions or concerns about anything I'm talking about, certainly reach out to your lawyer. Certainly reach out to me or someone on the KO team. We'd be more than happy to help walk you through it with more specific information. Okay, so these are the three main things that we're going to be covering today. Obviously, the new stimulus measures, the new laws that have been passed in the last month or so, various contract matters that our clients have been concerned about, that many businesses are concerned about, including force majeure, worrying about supply chain disruption or being able to perform, and then leasing concerns as well. And then the kind of final large bucket are personnel issues, right? Kind of high level HR matters. What should you be thinking about if you're in a position where you have to think about letting anyone on your team go, and how you can do that appropriately and thoughtfully. Okay, so just jumping right into it, right, with respect to the new laws and the new stimulus, the two primary that we're going to look at today, the Family First Coronavirus Response Act, the FFCRA, and the Coronavirus Aid Relief and Economic Security Act, the CARES Act. And specifically within the CARES Act, we're going to be paying attention to the Paycheck Protection Program, the PPP. There are a lot of aspects to both of these laws. We're going to be focusing primarily on those aspects that our clients, the businesses we work with, have been dealing with or asking questions about. So first, what is the FFCRA? Right, this is an extension of the Family Medical Leave Act. It requires employers to provide employees with paid leave for certain reasons related to COVID-19. These requirements are in place now, and they'll remain in place through the end of the year. And so specifically what it requires is businesses with under 500 employees must provide 2 weeks of paid leave to employees that are unable to work because they themselves are quarantined or experiencing COVID-19 related symptoms, or seeking a medical diagnosis related to those. It also requires 2 weeks paid leave at an employee at 2/3 of the employee's regular rate of pay if the employee is unable to work while caring for someone who's experiencing COVID-19 symptoms or is quarantined, or significantly, if they are caring for a child or if they're caring for a child whose school or childcare provider is closed for COVID-19 related reasons. That 2 weeks gets extended to a total of 12 weeks for any employee that has been with your company for at least 30 days. And so just to be clear, that's 2 weeks of paid leave at the regular rate of pay for any employee who they themselves are experiencing COVID-19 related issues, and up to 12 weeks for school-related closures at 2/3 regular rate of pay.
Hey, Dan.
Yeah.
Let me actually quickly announce for people that you can raise your hand if you have a question, and then if you do that now, and I'll give you the chance to ask Dan a question directly. And I have a question. That seems for some businesses under 500, that seems reasonable. They probably have the resources to do that. What about some businesses that are very small, say under 10 people? Do they also still have to do that?
Short answer, yes. Long answer is most likely. Right, there is an exemption for companies with less than 50 employees, but they need to be able to demonstrate that compliance with the FFCRA would jeopardize the viability of their business as a going concern. So it is a high bar there. That said, Mike, I am about to jump to some of the specific tax credits that have been implemented in connection with the FFCRA to try to offset some of that burden.
Yeah. Before you jump, David Halleck has the question. So basically, isn't that everyone with the kids out of school then?
Mostly, right? So the standard is you are unable to work or you are unable to telework because the school is closed or you can't get appropriate child care or your child care provider is closed. So I imagine for older kids, it becomes less of an issue. For younger kids, certainly it can be, right? And I imagine many of us on this call are secretly hiding out from our kids so we can do something like this from our home offices.
All right, David, did you have an additional question, or was that just what you had stated in chat as well? Because you have your hand up, sorry.
All right. Moving on. So here are the 6 qualifying reasons for leave, right? It's quarantine or isolation under order or being advised to self-quarantine. It's you yourself are experiencing a COVID-19 related symptom, or you're caring for an individual who is self-quarantined or has been advised to self-quarantine, and then caring for a child whose school or child care provider is unavailable. Of course, there's also the generic catch-all of anyone else experiencing similar conditions. So time will tell if there's something more to that. But Mike, back to the specific question that you asked, and I think this is really the key element of the FFCRA that is really beneficial or potentially beneficial for a lot of companies. It's that companies are able to get a dollar-for-dollar reimbursement through tax credits for all of the amounts that they pay to employees taking leave under the FFCRA. And while I've explained that to clients, their initial response is, well, I'm not in a position to float that amount of cash until the IRS can give me a tax refund. The key point of the tax benefits under the FFCRA is that employers do not have to pay upfront and seek reimbursement later. They can offset the cost of the leave by retaining a portion of the federal employment taxes that they would otherwise have had to pay to the IRS. So instead of paying payroll taxes, you retain them and use them to offset the cost of the FFCRA. And if that's not sufficient, you can request an advance refund. And while it's not completely clear what the process is going to be to get that advance refund, the IRS is committed to doing these or processing these quickly, even within 2 weeks of request. One final important point on the FFCRA, because it's an extension of the Family Medical Leave Act, the way we analyze what you can and can't do under the FFCRA is very similar. And so it's important that companies realize that they can't discharge, discipline, or in any way discriminate against an employee who takes leave under the FFCRA, or even if they file a complaint or institute a proceeding relating to the FFCRA. Okay, the next key, sorry, go ahead, Mike, did you have a question?
Oh, thank you. I was going to say, Ann Hogan pointed out, she said school is currently open, so they're not closed. Does that change things?
I imagine it would change things. My kids' schools are certainly still closed, but I imagine if schools are open, then yes, that would change the calculus of whether or not someone is
Right.
eligible for leave.
Right. So my kids, the schools are open, but they're remote learning, so I can't leave them at home. Right. So it's a little bit of a in between. So I don't know if that would impact things or if you've had time to look at that portion of it. But that was something.
I haven't looked at that. I would imagine that doesn't dramatically change, right? Because if children are home and need childcare, whether or not they're online programmings, I think the FFCRA would still apply.
All right. Thank you.
All right. So the CARES Act is another critical stimulus package. It authorizes more than $2 trillion to battle the economic effects of COVID-19. And there really is a huge amount here with respect to employer retention tax credits, expanded unemployment benefits. There are a lot of aspects of it that benefit individuals personally. What we're going to focus on is the Paycheck Protection Program, the PPP, which I imagine many of you have heard of. So a little bit about the PPP. It provides businesses with funds to pay up to 8 weeks of their payroll costs, including benefits. And so these funds come in the form of an SBA loan that can be fully forgiven when you use the loan proceeds for payroll costs, interest on mortgages, rent, and utilities. There are, of course, a few stipulations, right? Forgiveness is based on the employer maintaining its regular headcount or quickly rehiring anyone who has been let go, and then also maintaining salaries at consistent levels. And then forgiveness of the loan will be reduced if full-time headcount declines or if salaries and wages decrease. So most companies with fewer than 500 employees are going to qualify for PPP loans. And they don't have to prove that they were financially affected by COVID-19, nor do they have to prove that they can't get credit elsewhere. If applications for loans under the PPP opened last Friday for most businesses, and they will open tomorrow for sole proprietors, individuals, independent contractors. And if you have any interest in getting a PPP loan, you should definitely start the process now. Reach out to your bank, see if they are participating. Getting a loan under the PPP over the last week has been a bit like trying to get concert tickets, right? There's fear of money running out. There seems to be competition, not quite sure where to go to get an SBA lender who can work with you if you don't have an existing account with them. So it's really worthwhile to do the legwork now and try to get those applications in. And then one quick note, many of the clients that we work with are venture-backed or are owned by private equity firms. And if your business is VC-backed or PE-owned, your eligibility to qualify for the loan may be impacted by the affiliate attribution rules. These basically say that there are certain circumstances in which you may be considered an affiliate of your investors or owners other portfolio companies for purposes of determining whether or not you're under that 500 employee limit. So if you have questions about that, we can certainly help walk you through the issue or look at your company structure and help you with that analysis.
All right. If you have questions, raise your hand. Dan, I actually have a question.
Sure.
On that. Nope, you don't have it here. So I've heard both that you can actually apply with your contractors in mind as well. So if you have contractors that you work with and you want to pay them, you can include them in that amount. Is that accurate?
So my understanding is that the contractors would themselves be eligible to apply on their own behalf, right? And that it is largely limited to W-2 employees. But Mike, I can certainly confirm that. But that's my understanding for why there's separate applications for independent contractors.
Yeah, I wonder too. That's something worth looking in. I know a couple people have come in on the Q&A side with that.
Okay.
And then another question on that is there a difference for nonprofits? How are they treated the same under this law?
501c3s are treated the same under this law. Nonprofits that are lobbying organizations, I think it's 501c6 or I forget the specific designation. They do not qualify, but most nonprofit charities do qualify, and there's the same analysis for them.
Okay, great.
Great. So moving on from some of the new laws, the stimulus, and like I said, there is a lot there. There are some tremendous resources online, and pages and pages of frequently asked questions. But again, certainly feel free to reach out if you do have specific questions on those. The next bucket of items that we've really been trying to solve for and work with clients on relate to their contracts. Many clients have been reaching out, concerned about their ability to perform, wondering what the overall impact is going to be, the risk associated with their non-performance, and then also what's the impact on downstream contracts, right? If there are critical suppliers that aren't going to be able to perform, how can we handle our commitments to our customers? All right, and so we're going to go through how to analyze some of your contracts to identify risks and walk through what you can do to mitigate some of these concerns. Of course, it's very much a fact-specific inquiry, but hopefully some of these details will provide some guidance for you. The first thing that most people ask is, what about force majeure? Is this something that I can rely on? And so I think it's important to spend just a couple minutes on what is force majeure. At a high level, it is a contractual defense that is outlined in your contract, right? It generally says, it outlines certain circumstances in which a company's failure or inability to perform won't be considered a breach of contract, right? And so under the typical scenario, if someone breaches their contract, they're on the hook potentially for contract damages and other remedies that may be outlined in the contract. And if force majeure applies, they can avoid those. And so what I've listed here is a fairly common force majeure clause. You'll see this is very broad, right? It excuses performance, any delays or failures to perform resulting from causes beyond a party's reasonable control, right? And so again, that is very broad, and it really does open the door to use of this as a defense, particularly with respect to COVID-19. And so then as it relates to COVID-19, we need to think through, how does this actually work in context, right? You have to consider what actually is excused in the force majeure clause, right? Does it expressly provide for suspension or complete discharge of performance obligations. The prior example, as I pointed out, would have excused delay, failure to perform, or even breach of contract. Are there requirements necessary to invoke force majeure? Right? Notice is the most common, but oftentimes there are others as well. And so you want to pay attention to those requirements so that you don't miss the opportunity to rely on a force majeure clause if necessary. And then significantly, what constitutes a force majeure event? And is that the thing that actually caused the non-performance? Right? So in light of COVID-19, what is the event that we're talking about? Is it the fact that COVID-19 is a global pandemic? Did that cause the non-performance, or was it the subsequent governmental orders to shut down businesses or close offices? Right? There's really a lot here that context is going to govern. And then most importantly, were there other ways to perform? Right? Force majeure is not going to be a get out of jail free card. You have to be able to demonstrate that there were no other means by which you could have performed in light of the force majeure event. Okay, and then just a couple more points on force majeure. They tend to be reviewed very narrowly and strictly. So the language of the clause itself is going to be what governs. Payment obligations are rarely excused by force majeure, right? And the reason is that there are few circumstances in which a force majeure event would prohibit someone's ability to actually make a payment. The one example I can readily think of would be if banks were closed and you couldn't wire funds. That may be an example where a delay would be excused under force majeure. And then again, difficult to perform is not the same as impossible to perform or illegal. So be thoughtful about that. So then, in light of COVID-19, in light of our understanding of a force majeure clause, what should businesses be doing? Right? How can we look at our key contracts and begin to understand what's at risk and how can we mitigate some of that risk? And so first, I'd say identify what your material contracts are, right? And these are contracts that keep the lights on, and then contracts with suppliers that help us to be able to offer our products and services to our customers, right? And then work through the key provisions of these contracts, right? Think about what is being committed to, the representations and warranties you're making, whether there are rights to terminate, and whether COVID-19 is increasing the likelihood of one party terminating. Notably, in a lot of force majeure clauses, there is a right to terminate if the force majeure event continues for a certain period of time. So it's important to be aware of that. And then, of course, thinking through notice requirements, right? If performance is going to be delayed, whether for force majeure or otherwise, do you have an obligation to notify the other party? And then if you've identified that performance is at risk, right? Again, whether it's your performance or a supplier's performance or a service provider's performance, consider whether there are alternative means that you can be able to perform in light of that, or proactive steps that you can take with the counterparty to help solve for it. One of the things we often guide clients through is, a lot of the defenses in a contract are there once there's already been a major issue, once the relationship is blown up, right? And so are there things that you can be doing now with a supplier who may not be able to perform or who may be delayed to help solve for the issue? And then, of course, document all of your efforts to perform. And then I think it's important to have a grasp on what is the full impact of a potential breach, right? Are there contract remedies specified in the contract that are going to be difficult for your business? What are the other damages? What harm is the other party to the contract going to suffer? And then thinking through downstream contracts and whether those become at risk because upstream contracts are at risk. And then one primary issue that I think is frequently overlooked is anytime that you are potentially going to find yourself in breach of a material contract, there are unrelated contracts that are implicated, not just downstream contracts. For example, if you've ever taken on debt financing, your contracts with your bank are going to include, or contracts with your lender are going to include a litany of representations and warranties. Some of those require giving notice if you are in breach of any material contract. And so understanding those obligations, even though they're entirely unrelated to the contract at risk, are important. The last thing you need at this moment is to find yourself in violation of certain debt covenants because you failed to provide notice. And then finally, I just want to reiterate, engaging with the counterparty helps to solve a lot of potential problems early, and you can avoid some of the more dramatic consequences of a breach or of a failure to perform or of a potential failure in the supply chain. So going on with contractual concerns, one of the things that is often top of mind is leasing and rent relief. And your lease is just like any other contract, except it's more relevant now because many of our offices are closed. We're unable to use them, and we're also looking at a lot of economic uncertainty and potential cash constraints, right? And so a lot of the questions that we've received from clients are, how do I get out of paying rent? And it is not an easy answer, right? Leases are typically very landlord favorable, right? But we've also seen a lot of flexibility among landlords in the last couple of months, or last few weeks. And so what I recommend for clients is to first and foremost think through, are you already in breach of your contract? Is there something that breach of your lease? Is there something you already need to solve for? And the thing that comes top of mind is abandonment. In most sophisticated leases, there are clauses that say you can't abandon or you can't leave an office unopened for more than a certain period of days. And it becomes much more stringent with retail spaces or restaurants, right? Obviously, if there's an order for your office to be closed, you can't be there, but it's something that you should be proactively trying to solve with your landlord. And then analyze your lease just like you would any other contract. Think about that force majeure clause of your lease, if there is one, right? Again, it rarely can be used to forgive or to defend failures to pay, but there may be other relief in there. And then understand, again, what is your maximum exposure under your lease, right? It's the remedies for landlords in leases can often be very draconian, right? Up to and including accelerating all of the remaining rent payments that would be due following a breach. So if you're in a 5-year lease and you breach early on, that acceleration of payments is going to be extraordinarily difficult to manage, if not impossible. And where we've had a number of clients actually find success over the last couple of weeks is by being practical and engaging with their landlord, right? Landlords are not in the business of having space not be rented. And so, there's real value to the landlord in potentially extending the terms of leases in exchange for rent abatement now. We've seen landlords agree that rent payments will be delayed for the next 6 months, right? And at the end of the 6 months, they'll be due with or without interest, right? That can be a huge benefit to clients. We've also seen landlords agree to abate rent for a certain period of time in exchange for extending the lease for 6 months or a year, right? There's a lot of value in just working through the issue with the landlord and seeing where the flexibility is. And then one of the things that I think is just important to caution against is don't roll the dice and just assume that there's too much going on for the landlord to pursue claims against you. The world is going to normalize, and your breach of contract or breach of your lease isn't going to go away. And so the last thing that your business needs is to be subject to that litany of potential landlord remedies that follow a breach. Particularly if there's any kind of personal guarantee associated with the lease, in which case not only is your business at risk, but your own personal finances, your house, they become at risk as well. So be thoughtful, engage with your landlord, and whatever agreement you land on, make sure it's documented appropriately. All right.
I have a couple of questions. If that's or did you have more that you were clicking through too?
No, I was gonna keep going, but yeah, let's ask some questions, Mike.
Okay, sure. So some are follow-ups to kind of previous questions. So actually, let's go ahead and wait till the end, and we'll go over those.
Okay.
Because they're all more about what you've already talked about in a couple slides ago.
Cool. Sounds good. Okay, so the third kind of bucket under contracts is insurance, right? We've all been paying into insurance for years, and now there's a major issue. Is there going to be some relief under our insurance policies? The primary policies that folks ask about are general commercial liability, the professional liability coverage, and then business interruption policies. And as you might expect, there's less hope here than any of us would have hoped for. Our general commercial liability and professional liability policies are almost always policies that apply to cover claims brought by third parties against the policyholder. So it's not going to cover any kind of disruption based on COVID-19. However, in the event that you are in breach of a contract and it is related to COVID-19, if a claim is brought against your business, that's when these policies could kick in and provide some relief. And then business interruption policies. So these typically only cover losses that result from actual property damage, which would exclude most interruptions relating to COVID-19. However, there have been instances where contamination of physical property, right? In this case, actual contamination at an office could be considered property damage. That said, there are some very specific exclusions in most business interruption policies, and these followed the SARS epidemic from the early 2000s, where now most insurers are explicitly excluding losses caused by bacteria or viruses. And so, like every contract, it's important to look at the specific details of your policies. But also, several states have introduced legislation that would require insurers to retroactively cover business interruption claims related to COVID-19. So there may be some relief there. Though I find it difficult to hold my breath over it, given backdating of a contract. There are lawyers out there that I've been talking with who have actually been offering up looking at individuals or businesses' insurance policies to give a high-level view on what would be covered, what wouldn't. And so feel free to reach out, and I'd be happy to make introductions on that front if it would be helpful. Okay. And then the last key element, reductions in force, right? Despite everything, despite the PPP and the CARES Act, there is a lot of economic uncertainty, and with economic uncertainty, reductions in force often follow. And whether your business is facing a potential large reduction in force or small reduction in force, it's important to be thoughtful about it and to do it right. And so first and foremost, I always recommend that plan ahead and make sure that the benefit that the reduction in force will actually achieve the business goals that you need to solve for, right? And then you have to think through, so have a plan and think through your existing employment contracts, your handbooks. Most employees, almost all employees are employed at will, but not all of them, right? And some may be entitled to severance if they're laid off. Some may be entitled to accelerated vesting of some equity interest in the business that they're entitled to. So be thoughtful about these and understand what are the implications related to a potential layoff. And then consider your selection criteria for the layoff very carefully. This is the most heavily litigated aspect of any reduction in force. And document your selection criteria for who would be laid off. And make sure, of course, to avoid any kind of discrimination, whether related to age, race, sex, gender, etc. We always recommend, where possible, to provide some amount of severance to employees in exchange for a release, right? Specifically a release of claims against the company. And there are a lot of nuances here, particularly with respect to any individual who's laid off who may be over 40 years old. For a release of claims, for a release of an age discrimination claim to be effective, any individual over 40 years old needs to be given 21 days to consider whether or not they can sign that release. And then they often also have a ability to revoke their signature. So being thoughtful about that to make sure the releases are effective is very important. And then also for any group layoff involving an older individual, and in this case, a group layoff is 2 or more people if at least one of them is over 40. That 21-day period gets extended to 45 days. So individuals have 45 days to think about whether or not they're going to sign that release. And then under the Older Workers Benefits Protection Act, there's a number of additional requirements that you have to document in a letter to everyone who is laid off. And so there are a lot of traps for the unwary. And for any layoff, I think it's very important to consult counsel, but particularly with respect to any layoff where there's going to be a release or any group layoff. Okay, and so those are the big buckets. We have some extra time for some of those questions, Mike, that were raised. If you want to jump in.
All right, sure. So one, we were talking about independent contractors, sole proprietors. It sounds like they are excluded. Stacy Coachhausen took a look, and it looks like they're excluded from payroll cost calculation. So that'll impact how much you can borrow, and they need to probably apply themselves based on the answer she has. And that's in the quick Q&A, her specific terms there. In terms of questions, we had a follow-up question around the FMLA, and that was, wouldn't anyone laid off now that has kids in school have a lawsuit case with the requirement to pay that 12 weeks?
Yeah, David, that's a good question. I don't necessarily think so, right? I think if they are taking advantage of the FFCRA, if they are on leave to take care of a child and getting FFCRA benefits or intending to get FFCRA benefits, then potentially. But if their kids are on leave and they're able to telework and they have been working, then I don't think they would have a FFCRA claim.
All right, very good. And then we had another question from Gita. I hope I said that right, Gita. It is, what about, and I think it was back when we kind of compared the difference between, say, a nonprofit and a traditional business. This one was, what about startups versus traditional businesses? Are they treated differently?
Yeah, no, Gita, they're not. There's obviously the 500 and less requirements for who both of these apply to, whether you're talking about the FFCRA or the Paycheck Protection Program. But no, they don't make a distinction for businesses that are maybe just getting off the ground or have less than 10 employees or 5 employees, whatever the case may be.
All right. Those are the questions that I have so far. Any other questions, you can enter them in the chat. There's a Q&A box. I've got them all up. We're going to count from 5. Oh, the 1099 question. Gita, can you give us more details about what your specific question is? Is it if it's the 1099 question around independent contractors and the payroll costs or the payroll protection program, it sounds like Stacy did some research and that they are excluded from the cost calculation.
Yeah, and Gita, I can follow up with this on this one with you offline. Obviously 1099 contractors are treated very different from W-2 employees. The FFCRA, the requirements to provide paid leave, that's not going to apply to 1099 contractors. It would apply to W-2 employees. And if you're talking about as it relates to reductions in force, 1099 contractors are what you can do with respect to letting contractors go is a creature of their contract with you, as opposed to the offer letters you may have with a W-2 employee, and you typically don't have the same level of releases and claims that you would have to be solving for as you would with W-2 employees.
All right, I think you answered it. I got to thank you.
Cool. All right.
All right, any other questions before we'll go ahead and call it a day? You got 9 minutes. And Dan's off. All right, I don't see any questions coming up.
Yeah, please feel free to reach out if anything comes up after the fact. More than happy to chat through it with you.
Excellent. All right, and if you, I will make sure that when we do out, we'll mail out a copy or link to the recording, and then we'll be sure to get you Dan's contact information in that email. If you're interested in our webinar next week, it's going to be on, well, we've talked about the topic of how you can present better over Zoom and connect with people, and the link to register for that is in chat, and we'll email that out as well. So I'm going to go ahead and end this. Everybody have a wonderful day and a great rest of your week.
Thanks all.